2017 CF 15684, State v. Nelson, back from our lunch recess. Ms. Burdick, is State ready to proceed?
We are.
Mr. Lahr, defense? Ms. Simmons?
Yes, Your Honor.
Mr. Nelson, you ready?
Yes, Your Honor.
All right. All right, so moving into the charge conference, do we have a packet of the agreed instructions already prepared that's been printed?
Forward it to you, yes, sir.
You have a printed version?
No.
Is there a way that you can print it?
Your Honor, while we're waiting for that to be printed, I did want to place on the record that at this point, we would ask for a judgment of acquittal based on the prior grounds that we did at the end of the state case. Typically, we do that after the defense case. We didn't do it before we left, so I'm making that motion now based on the same arguments that I made prior to this time.
All right, any additional arguments? Ms. Burdick?
Nothing.
Any additional reply, Mr. Lahr? All right, the court will deny the defense motion for a renewed motion for judgment of acquittal with respect to count 1, count 3, count 4, and count 5.
Mr. Hanford?
Yes.
This is the first day for me to run back. You didn't realize it wasn't on. We can get started with that if you.
Okay. All right, I'm still in the process of going through the jury instructions, but I'm going to take a brief recess, and I'll be back. All right, so I've reviewed the packet of instructions provided to me by the state along with the verdict forms. And Ms. Simmons, have you and Mr. Lahr had an opportunity to review that with Mr. Nelson?
Your Honor, yes, Mr. Nelson had a copy yesterday. We only had a couple issues with it, the copy as presented.
Okay. Why don't you go ahead and we'll go through those issues?
Yes, Your Honor, well, if we could start, I guess, with 3.12D, the legally interlocking counts.
All right, give me one moment. Okay.
The state put that in there, but they're not requesting it. We think that it does need to be in there. So I don't know if you want to hear from the state first, but essentially their argument is that it's confusing given the fact that there's two series of count 1, premeditation versus felony murder. And I think that a simple line to clarify that this only applies to felony murder will clear up any confusion that the state has brought up to me.
So the defense is requesting 3.12D be given only with respect to the felony murder theory under count 1.
Correct.
And is what the defense proposing, is this the form of the instruction the defense is requesting?
No, Judge, so obviously the counts need to be filled out properly because this is just the standard. We're asking for the standard instruction. State brought up the fact that they believe it's confusing given that premeditation is an option. I suggested that it could help to have a clarifying sentence added. That's not necessarily something that we're requesting. It was only a response to the state's argument.
Right, and what do you believe are the legally interlocking counts then? Because this has, what I have, just to make sure we're on the same page, has in brackets A and B. Is that what you have?
Yes.
Okay, so what are the counts that you're requesting, the B and, what is A and what is B that you're requesting?
Well, A would be murder, first degree felony murder. And then at least one of counts 3, 4, and 5 would need to be found to support felony murder. I understand the state's assertion that it may be confusing depending on how it's worded, but I think that we can create a sentence that is not confusing for them, that's not quite the standard, but includes the general sense of the rule.
Okay. I guess before we get into the minutia, let's sort of take the 20,000-foot approach first. Just conceptually, what's the state's position?
Judge, so the Rule 3.12D, legal interlocking counts, applies to the crime of felony murder. And what it essentially says is that when you have a defendant who is charged with felony murder and the state charges the underlying crime. So let's say, for example, a defendant, let's just say it's sort of just a felony murder, straight up felony murder case, no premeditation, and the underlying felony robbery. So one is murder, and the state specifically enumerates that the underlying felony is robbery, and then count 2 is robbery. In that very specific, that very specific circumstance, this issue applies. Because if the jury, in that specific circumstance, if the jury were to come back not guilty on the robbery, but guilty of felony murder, it would be a true inconsistent verdict, and the judge would have to throw out the felony murder because the defendant can't be found not guilty of robbery and guilty of a felony murder based upon that robbery that occurred during the course of that robbery. So that's what the case law says all about, and where this jury instruction comes from. The issue in a case like this, and I quite frankly, in this situation I always argue that this is confusing. To demonstrate the confusion, all due respect to defense counsel, when it says count A and B, and you ask defense counsel which is A and which is B, and she said A is the felony murder, that's not correct. B is actually the felony murder when you read and understand the instructions. So right off the bat, when we're trying to explain it to you, it's confusing, and it demonstrates that this is a very confusing instruction. So I have several reasons, particularly in this case, why it shouldn't be given. Jury instructions are a guide. These are, although we have standard instructions, it is up to the trial court to decide what is the law that is given to the jury, and the goal is to make sure it is first, obviously legally correct, which we're going to have an issue with making this legally correct, and that it is not misleading or confusing to the jury. And I think it is going to be virtually impossible to make this instruction legally correct and not confusing or misleading to the jury because of the facts of this circumstance, of this case. So first and foremost, this jury instruction says, if you find that the crime in count A has not been proven beyond a reasonable doubt, you must find the defendant not guilty on both counts A and B. In this case, that is absolutely legally an incorrect statement because the defendant in this case, the state is presenting both the theory of felony murder and premeditated murder. And the Florida Supreme Court does not, even though the state charged in the indictment premeditated murder, we can still present both theories to the jury at this point, felony murder and premeditated. The law does not require, and this is going to be something we're going to talk about, I believe, later, because the defense is asking for special instruction. The Florida Supreme Court has found that you do not give them special jury instructions. They do not have to find that one or the other is unanimous. The jury does not have to be unanimous as to premeditated or felony murder. And so, quite frankly, 6 of them can believe it's premeditated murder and 6 of them can believe it's felony murder, and they can come back guilty of first-degree murder. And so there's no requirement for the jury to be unanimous on which theory it is. There's no requirement for them to tell us which theory it is. So because there are 2 options when it comes to first-degree murder, to tell them in a jury instruction that if you find this, you have to find them not guilty of the murder count, that is absolutely legally wrong. And so we can't have that statement in the jury instructions. The further issue is that there are, in this case, 4 underlying crimes that they could find for the underlying felony. There's burglary of a dwelling, there's robbery, there's carjacking, kidnapping. Now, although we agreed to the JOA as to the burglary of a dwelling, we technically, although I haven't done it in here, we technically could still argue that that was a felony to constitute the underlying felony, because the state is not required to say what felony they're relying on when they charge first-degree murder. And so just using even just these instructions, because again, I didn't want to overly complicate the felony murder charge for the jury, and since the burglary of a dwelling count has gone away, the state, we're not going to argue that the underlying felony is burglary of a dwelling, but that still leaves us with 3 things that could be the underlying felony to support felony murder: kidnapping, carjacking, and robbery. So what you would have to do to even begin to try to figure out how this instruction could be legal, you would have to say, if you find him guilty, and first, again, you would have to somehow explain that it only applies to murder, but you can find him guilty of premeditated. The guy next to you can find him guilty of felony. It gets very complicated. But in a case like this, where you have multiple felonies, if they find him not guilty of kidnapping, but guilty of carjacking, they can still find him guilty of felony murder. So you would have to somehow explain. It's not just as simple as saying count A and count B. This standard jury instruction is designed for the very simple circumstance where it's count 1 is felony murder, with the underlying felony being robbery, for example, and count 2 is robbery. And yes, in that situation, you could adjust this jury instruction to make it pretty simple and make it work. But in a situation like this, you would have to say, if you find him guilty of carjacking, you can convict him of the felony murder. But if you find him not guilty of this, well, you can still convict him of the felony murder if you convict him of the kidnapping. It gets extremely complicated and extremely convoluted, and I do not believe there is a way for us to make this what the Florida Supreme Court says these jury instructions should be, which is 1, legally accurate, and 2, being able to explain it to the jury so that it's not confusing or misleading. And then my final issue is, I do not believe there's any legal reason for this jury instruction. And what I mean by that is, the court, in this situation, if the jury were to come back guilty of first-degree murder and not guilty of all the underlying felonies, we would never have an interlocking issue, because the jury could believe it was premeditated murder. So we, assuming Your Honor agrees with the state that there should not be any special findings as to whether it was premeditated or felony murder, we will never know what the jury went with, and so therefore this instruction will never become applicable. But more than that, let's just say, let's just take that simple situation that I've explained before with simple felony murder with the underlying felony being robbery. I don't really understand the point of this jury instruction, because if you had a situation where a jury was charged with felony murder and robbery, and they came back guilty of the felony murder and not guilty of the robbery, the court can simply dismiss the felony murder. We don't necessarily need the jury to know that the law doesn't allow us to now convict him of felony murder. The court could just say, all right, this is a true inconsistent verdict under the law, and the defendant is hereby, released from the felony murder. And, it's to me, it's really not any different than when you have, a count of aggravated battery and a count of aggravated assault, with the aggravated assault being the lesser included of the aggravated battery. If the jury comes back guilty on both counts, we as the parties and the judge know that, okay, well, he can only actually be convicted of the aggravated battery, and so we're going to get rid of the aggravated assault. By analogy, if a jury were to come back with a true inconsistent verdict, the judge can say, this is a true inconsistent verdict, and I'm dismissing the felony murder. But you're never going to have that in this case, because the jury is being presented with both theories. So because of that, no legal reason and to put this instruction in, and I don't believe it can be made simple and straightforward for the jury.
I'm going to defer on this issue for now because the court rules on requested instructions. I don't have a requested instruction. I have a draft that form that was inserted in this document by the state, but it's not being requested by the state. The defense is requesting something, but this, whatever that something is not before the court. I understand now conceptually the parties' positions, but in order for me to make a ruling, I need the defense, because now I understand the defense is requesting something. I need to see what that something is in a final form and present it to the state, see if there's an agreement. If there's not, then present it to me, and then I'll hear any follow-up argument in the context of actually seeing what it is being requested by the defense. All right, any other issues of disagreement between the parties?
Yes, Your Honor, let me find it. Is the state asking for 6 through 10? I don't have numbers. 3.9, weighing the evidence.
3.9, give me 1 second. All right, 3.9 is weighing the evidence.
Yes, Judge, we're not asking for any of 6 through 10. I'm not sure what the state's position is, because I did forget to discuss that with them at the close of evidence.
Yeah, we're asking honestly for number 9, has the witness been convicted of a felony?
I'm sorry.
We're asking for number 9, has the witness been convicted of a felony? But obviously I leave them in to make sure that we agree with what should be and should be out.
Okay, so both parties agree that what is currently numbered as 9 would remain.
Yes, and number 6.
And I'm sorry?
And be moved to number 6.
Okay, well,
Renumbered.
before we renumber,
Okay.
is either side requesting 6, currently numbered 6 or 7? Or do both parties agree 6 will not be given?
The state agrees that 6 should not be given.
We agree.
That 6 will not be given?
Correct.
Okay. 7?
The state does not need number 7.
We're not requesting that.
Okay. 8?
Yes, the state is requesting 8.
And state is requesting 9.
Correct.
State and defense agree 10 is not applicable?
Yes, correct.
All right, so that will be edited to take out the give as applicable, delete currently numbered 6, 7, and 10, renumber 8 as 6, and renumber 9 as 7.
And on that same page, unless the state already did it, the portion about defendant testifying can be, okay.
It's included in my version. Is that included in defense
It
version?
is, but it's
Okay.
just folded, and I didn't know if they changed it already. And removing defendant not testifying.
Okay.
In 3.10, rules for deliberation. Number 7, I mean, there were no questions from jurors unless the court is including the initial question before the evidence started.
At first, when I read that, I didn't understand it, but then I think it makes sense given it was treated as a question and I said what I said, so I think that's appropriate unless you don't think that's accurate or there's some other objection from the defense to that.
No, you're
Okay.
in 3.12, verdict,
Right.
and there's a bolded portion, I don't know if the state changed this since this morning. Sorry.
I don't have any bold under 3.12.
Well, then it's been moved to 7.2, and I'm sorry to go backwards, but
Okay, 7.2.
it's been moved to first degree murder 7.2.
Give me 1 second. Okay, 7.2.
The second paragraph about the theories of count one not needing to be unanimous, we recognize as in standard instruction 3.12 and don't generally have an objection to moving it there, and we recognize that the case law is against us on this position, but we would object to that language for the record. But I do recognize that it is in the standard instruction and that this is the current state of the case law. We disagree with the case law.
Okay, I understand that objection. Are you disagreeing that the case law, because my version has it in two places. I have it in under 7.2 as the second full paragraph, and then I have it, it's not bolted, but it is under 3.12 as the fourth full paragraph in my version.
I was under the impression that the state was requesting to move it from three, you want it twice?
In the email I sent you, like I said, what the state is actually requesting, because the jury is told repeatedly that it has to be unanimous and they have to make a finding beyond a reasonable doubt as to each count. The state believes it is appropriate to put it in two different places. First, when they are considering the crime of first-degree murder, they need to be told that they don't have to be, they can come under either theory. That it doesn't have to be all 12 of them agree with premeditated or all 12 of them agree with felony murder. They have to come to a verdict as to felony, as to first murder. And so the state believes that, the jury is going to be considering, one would assume that the jury is going to be considering each individual count. So when they are considering the count of first-degree murder, they really need to have that instruction in front of them. But then later on in the instructions, when it talks about the verdict, and that's again where it's talking about everything has to be unanimous, it's important there, it needs to, that with respect to that particular count, it has to be unanimous as to first-degree murder, but not as to which theory of first-degree murder. So what I will say is, Ms. Simmons is correct. It's part of the standard instruction for 3.12, which is why I have it there with 3.12. The state is asking that it actually be read twice up in the first-degree murder portion of the jury instruction, where I've also put it in there, and here. And it's not uncommon. There are many instructions in here that are read multiple times. The aggravation of a felony by a weapon, I think, is in here maybe 6 times. So it's not going to be weird for the jury to hear the same instruction more than once.
Ms. Simmons?
Judge, we would object to it being read twice. Well, we have objected to it at all. We would object to it being read twice. We have no preference about which place it appears, if it appears once.
All right. Having read this particular paragraph, it is in 2 locations, appears to the court.
Judge, I'm sorry to interrupt. It's not part of the standard instruction for 7.2. It's only part of the standard instruction for 3.12.
Right.
That wasn't clear.
So I've read this paragraph that's at issue. The defense concedes the case law is against them on that issue. I'll overrule that basis for objection, as I'm controlled by existing case law as it stands right now. With respect to the argument that it's not part of the 7.2 standard and shouldn't be given there, then the question before the court is if this modification of the standard instruction is an accurate statement of the law. I find that it is, given the current state of the law. Whether placing it here would confuse the jury, I agree under the circumstances of this particular issue and this particular instruction, I believe it actually would help prevent confusion of the jury. And since it's not needlessly, it's not a very long, it's four lines that I'll be reading and they'll be reading when they get the written copy. I don't think there's any danger of confusion given the short length of the instruction. So I'll I'll allow it to be given and overrule the defense objection. Allowed to be given in 2 locations as proposed by the state and what's performing. Ms. Simmons, any other?
No other issues with the, well, we have there's 2 more things. A requested instruction that I can bring to the court, and also an objection to the verdicts form. So however you prefer, whatever order to do that in.
All right, let me go through some of because some of these things we've touched on already, so I won't repeat that, but let me go through some other issues that I have as well. All right, with respect to count 4, the standard instruction lists robbery and assault as category 1 lesser included. Did both the state and the defense agree that those would not be given as lesser included, category 1 lesser included offenses for count 4?
Yes, sure. That was the state's understanding.
Mr. Lahr?
Sure.
We're just asking for the grant of
Okay.
not for the other 2.
So the defense is in agreement that for count 4, the lesser included of robbery and assault will not be given.
Correct.
All right. Mr. Nelson, have you had a chance to talk with your attorneys about that?
No,
Would you like a moment to do that?
just a moment.
Sure.
Thank you, Your Honor.
Thank you, Judge. We're ready to proceed.
All right, Mr. Nelson, you had a chance to talk with your lawyers regarding whether you want to request robbery and or assault as a lesser included offense to count 4, which is carjacking with a deadly weapon.
Yes, Your Honor.
Do you need any more time to talk to your lawyers about that?
No, Your Honor.
Okay. And your lawyers are telling me that they've made a decision that they do not want those given as category 1 lessers for count 4. Do you agree with that decision?
Yes, I do, Your Honor.
Or with respect to count 5, which is robbery with a deadly weapon, an additional category 1 lesser of that is assault. Again, that was not included. Both the state and the defense are in agreement that that will not be given for count 5. That is assault.
Yes, sir.
Yes, Your
Mr.
Honor.
Nelson, have you had an opportunity to talk with your attorneys about whether assault should be given as a category 1 lesser included offense in count 5, robbery with a deadly weapon?
Yes, I have, Your Honor.
Okay, do you need more talk with them about that?
No, sir.
All right. It's my understanding, well, what the defense actually hasn't stated its position on this.
We agree with only heading theft.
Okay, so your attorneys are telling me that they've made a decision not to ask for assault to be given as a Category 1 lesser included offense in Count 5 robbery with a deadly weapon. Is that your understanding, Mr. Nelson?
Yes.
All right, do you agree with that?
Yes, I do, Your Honor.
Okay. All right, 3.9C, the standard instruction on eyewitness identification has not been included. Both the state and the defense agree that is not going to be given?
Yes, we talked about it.
Yes, sir, I think that was discussed with Mr. Lowry, but we're in agreement.
Mr. Nelson, have you had a chance to talk with your lawyers about whether the standard instruction on eyewitness identification, 3.9 sub C, should be given?
Yes, Your Honor.
You need more time to talk with your lawyers about that?
No, sir.
Do you agree with their decision that that not be given?
I agree with that decision, Your Honor.
Thank you. And with respect to 3.12A, there's some bolded language in brackets, except as explained in the instruction for legally interlocking counts. Is that sort of a placeholder, if you will, depending upon the court's ruling?
Yes.
Okay, so again, I'm going to defer on that for the same reasons. Once I'm actually presented with some proposed instruction, then we could address both that proposed instruction as well as 3.12A in terms of that additional language. All right, with respect to 3.13, although it's not on, the number's not there, but submitting the jury regarding the exhibits.
I could not get 3.13 to stay there.
That's fine. We all know it should be there, so.
It would not stay.
All right. There are voluminous exhibits. My suggestion would be that, with respect to that, that all of the exhibits would be sent back to in the jury room, except weapons, biohazards, which we're going to need to identify, but the statement be made that all the exhibits will be sent back with you except the specifically enumerated ones. If you wish to see those, then please request that in writing. In addition to weapons, biohazards, there's some videos, there's some audios. Is the state requesting to send back a sort of internet blocked computer that's been done in certain cases, or do we want them to come in and either listen or view it here in the courtroom?
We can send back my MIS guy is here, Judge, and he's saying he can give me a computer that is clean, so we'd like to do that, and we don't have to sit here. They don't have to.
What's the defense position on that?
I'm sorry, Judge, we were provided with something that was a distraction in the middle of that, so.
I'm sorry, did you hear what it was?
No.
Okay, the question is with respect to certain items in evidence, video, audio, whether the state has a computer, in other cases, I've done this by agreement with the defense, sent back, there's no internet access, the only thing it has the ability to do is to play the audio and video evidence in the jury room without having to come back in here.
Right, we don't have objection to that.
As long as we can check it out beforehand.
Absolutely, you'll have the right to look at the before it goes back. So what the
I will.
state and the defense need to do is go through the exhibits and determine which one, because I have a list of all the numbers. and Madam Clerk may have it as well, but let's just go through it so we can make sure we've identified the weapons, some of the potentially biohazardous material. Anything else that either state or the defense should believe should not be sent back? And I guess, how do we want to define biohazardous? Is that in a broad sense? For example, if the state's position is this piece of clothing has blood on it, that will stay here?
They don't have a sticker on it. Anything that is an actual biohazard will have
Oh,
a
a sticker on
It has
it.
a sticker on the evidence bag. And we can still send back the gloves, because even if it's not a biohazard, they really arguably shouldn't be touching it, so. But anything that is it would be, I mean, just off the top of my head, it would be the towel, the shirt, the watch, the zip tie. So there's a zip tie that could go back because that's not a biohazard, but the zip tie that was actually around her wrist would be a biohazard.
Okay. So what I asked the state to do is go through it, identify the exhibits, let the defense look at it. If the defense believes there's additional items that should be kept here, we can take that up. If there's a dispute and the defense thinks certain things should go back that the state believes should stay here, I can address that. And you also need to check in with the deputies just to make sure that their security concerns are addressed in terms of what is a weapon, et cetera. Okay?
Can I ask the clerks, where is the evidence right now? It's in the, I'm assuming Your Honor wants to take care of that this afternoon.
That's a good, yes.
The
Yeah.
clerks could have the evidence brought here, so we can do that when we're done doing this.
Yeah, I believe it's right in the back in the evidence room, correct. Okay, sure. All right. All right, Ms. Simmons, you said there was an issue with the verdict forms?
Yes, Your Honor. Two things with verdict forms. One is something that Mr. Lar will argue, but the first is the forms that the state provided. I think this could be done in one of two ways. They've chosen one way. We would request that the verdict forms list the charges and then have a special verdict for the weapon, so that it would just read first-degree murder, second-degree murder, manslaughter, and not guilty, and take out all of the redundancy with a weapon versus without a weapon, and add a special instruction, or a special verdict form for whether a weapon was used or not for each charge, for each verdict form.
Okay. With respect to this weapon aspect of it?
Correct.
Okay. Ms. Hicks, does the state object to that?
Yes, it's not legally, it's not required, and in fact, the jury instructions specifically tell them when under the special instruction that's in each count about aggravation of the count, and this would apply to the first-degree murder count, and it would apply to the kidnapping count. It would not apply to robbery or carjacking because those are elements of the crime, essentially part of the jury instruction. And so the jury instruction specifically tells them, it gives the definition of a weapon, and it says that if you find it was a weapon, you should find him guilty of first-degree murder with a weapon. If you find that it was not a weapon, you should only find him guilty of first-degree murder. So if we're giving that standard instruction, telling them that they should find him guilty of first-degree murder with a weapon or first-degree murder, I don't understand why we would then break it up in the verdict forms, which goes completely contrary to what we're telling them in the actual jury instructions. This isn't like a firearm where it's 10-20 life, where we have to know if they carried it, displayed it, discharged it and caused the death. It's not a 10-20 life upgrade. It's just either it's a weapon or it's not.
Okay. Ms. Simmons, reply. Nobody's given me any case law, and I believe there's a reference to concurring opinion on the Florida Supreme Court on this issue, but I don't know if there's something that's come out later, either definitively making a ruling one way or the other on this.
No, it's our understanding that either way is acceptable. If there's no case law that would prevent either.
Does the defense agree? Because when I was looking through that on this issue, it did appear to me that the instructions do instruct the jury of what they have to find. For example, in the forms as they're prepared by the state, second-degree murder with a weapon, to make that finding, they are instructed on what they have to find in order to make that, reach that verdict. That is what Ms. Hicks was referring to, that this is already addressed. It is addressed. They are instructed on it. It's just a matter of how we put it in the form. Do you agree they are instructed on it?
Yes.
Okay.
Well, it's even beyond that. They're not just given like the weapon. They're actually instructed the exact
Right.
language of the statute, of the standard instruction says, find him guilty of first-degree murder with a weapon. And what they're suggesting is that we don't even give them the option of first-degree murder with a weapon.
Okay. All right. I will. I agree that under the circumstances, again, of the instructions that I have, that this verdict form as prepared by the state, that'll be given. I will deny the defense request for a special finding separate from the verdict form that's already been prepared.
And we have a requested instruction and a requested special verdict form.
Okay.
Based on Mr. Nelson's testimony.
Do you?
Yes, I've given
Okay.
a copy to the state. If I could approach.
Yes.
I'm approaching with a requested instruction on insanity defense based on Mr. Nelson's testimony this morning. And also a special verdict form request that Mr. Lahr is going to argue.
And the state has both of these?
Yes, sir.
What I have, 3.6A, insanity, it's a one-page instruction, proposed instruction. I have, it looks like I have two special verdict forms. One deals with, they both deal with first-degree murder, and then one has a reference to, appears to be the felony murder, and then the other reference to a premeditation, and that's a probably very bad summary of what I'm looking at, but just, Ms. Hicks, do you have both of those forms?
Yes.
Okay. And then I also have a case, Shepherd v. State. Yep.
Yes, sir.
Okay. All right, go ahead. Is it Mr. Lahr or Ms. Simmons that's going to make this argument?
I don't think it matters which one
Okay.
you pick up. I'm arguing the insanity. He's arguing for the special verdict form.
Okay. All right, go ahead.
Yes, Judge, based on Mr. Nelson's testimony this morning, we would request the insanity instruction. There was testimony elicited by the state that Mr. Nelson suffers from mental illness, is on several different medications for that, and when asked specifically whether he knew what he was doing at the time of the offense, he had said no. And so, given the case law on special instructions, we would argue that his testimony supports the elements, gives some support to the giving the instruction, the low standard required put on evidence in support of a special instruction. So we are requesting the insanity instruction at this time. Sent a copy to the state. I didn't receive any errors or requested changes, although I understand they are checking.
All right. Ms. Hicks, are you responding for the state?
Yes, Judge. The state is objecting to the insanity instruction being given. There's just really no evidence of it. First, the defense obviously never presented the state with notice that they intended to rely on the insanity defense. I read this Shepherd case. The Shepherd case involved a lot of things that are not in this case. I'm sure Your Honor can read it. But based on a simple statement by the defendant that suggests he has had some sort of mental issue at the time was committed, which is completely inconsistent with what he told law enforcement in the confession that was played. I don't believe that there's any basis to give the insanity instruction. There's any way this jury could legally find that the defendant was insane at the time that the crime was committed.
All right, give me, I wasn't sure which of the forms the Shepard case applies to. So Shepard applies to your argument, Ms. Simmons?
Yes, the
All right.
insanity, mostly to the fact that there was no notice given. And in this case, I'd just like to add that there wasn't notice given because it wasn't something that was going to come into evidence until those questions were asked by the state. We really had no reason to believe that we would request this instruction until Mr. Nelson's testimony on cross-examination when he answered the state's questions regarding his mental state at the time of the offense. The instruction does say that the jury can consider the testimony of expert and non-expert witnesses, and the state's argument really goes to weight, like whether they believe someone or not, and credibility, and they can argue that in closing that it's inconsistent with other statements, but as the case law for general requested instructions indicates, it's really just a low standard to have an instruction given. And from what was testified to this morning, it's our position that there's enough to give the instruction.
All right, give me a moment to read the Shepard case. All right, Ms. Hicks, I've had the chance now to read Shepard. Any additional argument from the state?
The issue here is that, as we said, we were never provided notice that this would be a defense. And if they had provided us notice that they would be relying on the insanity defense, it would have triggered certain rights that we would have had to have them evaluated and the like. Of course, that didn't happen. And if you have a situation where all it takes to get the insanity defense is a defendant taking a stand and making some sort of claim that he can't remember what was happening at the time because he was having some issue, if that's all it took, you would get the insanity defense in virtually every single solitary case. There has to be evidence of some sort of mental defect, mental disease, and all we have is a defendant claiming, inconsistent with other testimony, that he was having an issue at the time he committed this crime.
Ms. Simmons?
But I think it was more than he was having an issue. He testified that he was mentally ill, which I think was also in his confession, that he takes medication, which I think was also in his confession, that there's something wrong with my brain. And he was asked directly by Ms. Burdick about his mental state at the time, and he said that he I don't have the actual transcript, but he said that he did not know what he was doing at the time. And there's no evidence that he did. The state attempted to impeach him with a letter written, but that's not an evidence, and that is merely impeachment, and therefore cannot be considered substantive evidence.
Ms. Simmons, what's the defense response to its argument about the untimely notice and the prejudice?
Yes, Judge, I can rely on the case law that I provided to the court and just reiterate the fact that it's not untimely because it didn't come up as a possible defense until the testimony this morning, which was elicited by the state, not by the defense, and therefore it was timely because we told them before lunch that right after the testimony, that we planned to request this instruction, and they would have to show some sort of prejudice. There is no expert testimony for them to rebut, so it's our position that they can't show prejudice to the instruction.
But what about the argument the state has no ability to get their own expert to evaluate your client on this issue? How could that? It appears in the Shepard case that these were there were pre-trial proceedings where, according to the 5th DCA, quote, both the state and defense counsel were aware that Shepard's insanity would be an issue at trial. That's not the case here.
And again, we were unaware of this. and it was elicited by the state, so that's, I have nothing further to add. And just they haven't established prejudice. I'm sorry. They have not established prejudice.
All right, with respect to the defense request for the insanity instruction, I'm going to deny that request. I've reviewed the Shepard decision, and the Shepard decision is distinguishable from the case before the court. Reading, and I'm confined to, I don't have the actual trial court record, but just reading the opinion of the Fifth District Court of Appeal in Shepard, I already quoted one line that both, in that case, unlike this case, both the state and the defense counsel were aware that insanity would be an issue at trial before the trial actually commenced. In addition, in that case, unlike the case here, the defense counsel moved the court to appoint an expert to assist the defense in proving that Shepard was insane at the time of the charged offenses. That did not occur in this case. In addition, the evidence presented at trial in the Shepard case was not the defendant's testimony, but was the testimony of other witnesses that both parties were apparently aware of. And so the Shepard case actually seems to turn on its holding that the trial court failed to conduct a Richardson hearing, treating this as a discovery violation by the defense that should have been addressed by the state and the court in that manner. Of course, the testimony of a defendant can never be a discovery violation because there's no duty ever to disclose that until if and when the defendant testifies at trial. So I don't believe it is not a Richardson violation to the extent what the state or the defense is trying to do. It couldn't be addressed from the court from that perspective, which is another just a legally distinguishable issue in the Shepard case. After, in that context, then the Shepard case concludes by saying there appears to be a lack of prejudice to the state. Of course, for the reasons I just articulated, that the defendant has the right to remain silent until the moment he or she decides to testify, the state always runs the risk of having a defendant testify to something that they are not prepared to address. However, the Florida Supreme Court has adopted specific rules with respect to the insanity at the time of the offense issue to require a certain notice to the state to allow the state, with respect to that issue, to be notified in advance to prepare for that occurrence at trial, which distinguishes this insanity issue from other issues which the defendant may have no obligation to disclose whatsoever. In the context of this case, where I've already distinguished the posture of this case from Shepard, here the defendant chose to testify at trial, during trial. Yes, it was elicited, some of the issues during cross-examination. I don't think that changes the analysis. There would just be no way to effectuate the plain language of the rule regarding the insanity defense to allow a defendant to raise that for the first time through no other means except his own or her own testimony from the witness stand in the midst of trial, after the jury has been returned, after jeopardy is attached. I believe it is untimely. It's, as a matter of law, prejudicial because the state had no opportunity whatsoever to have an expert examine Mr. Nelson on this issue prior to trial. It's prejudicial, and under the totality of the circumstances of this case, I believe the only appropriate remedy is to reject the defense's request for this insanity instruction. Mr. Lahr, you're going to address the special verdict forms?
I am, Your Honor.
Okay.
We're asking for the special verdict form for the following two reasons. First one is, as the court recalls, I have separate JOA arguments for premeditated murder and one for felony murder. Ultimately, one of the courts is going to wind up evaluating this information if he is found guilty of murder. It's going to be the Florida Supreme Court or it's going to be the 5th DCA. The problem is they go through the evaluation, they may well find that because of the premeditation is not strong, that they may say, you are absolutely right, the JOA as to premeditated murder probably should have been granted. But then the response would be, well, they still have felony murder, so he's still guilty of murder. Well, I'm sorry. The response might be, well, there's this other felony murder out there, so of course then, with the way our laws are written right now, then he's guilty of first-degree murder. But if you imagine the scenario is that all of the jurors sat there and said, we believe it was premeditated murder. However, when we were evaluating whether it was felony murder, they said no, we could not, the state did not be beyond a reasonable doubt. So what it in essence has is you have the court saying that the one verdict was not appropriate and JOA should have been granted. Then you have the jury on the other hand saying, well, we didn't find that that was proven beyond a reasonable doubt. And so what the true verdict should be at that point would be not guilty. Because of the way that the law is written, there's no way of being able to know what their decision is when they're being evaluated in totality. And so we think, at least on that portion, that the court needs to be aware about what are the decisions of the jury. If they've rejected felony murder and they're doing the evaluation on the premeditated murder, then they can make a more informed decision. It just doesn't seem to make a lot of sense to me that you would have these two different theories operating at two different times to say, yeah, they're both joined. Because again, there's different factors that go into each. Premeditated murder does not require a felony. Felony murder does require a felony. So that's why we're asking for that instruction. The second thing is that we're going to be going, if he is found guilty of first-degree murder, we're going to be into a penalty phase, and there's two aggravators that I believe the state has listed, one being, of course, that it was CCP, cruel, calculated, and premeditated. The other aspect that they're also going to be moving forward on is kind of on a felony murder theory. And so these aggravators would have to be proven, but the problem is the jury, at the point where we are doing the verdict now, would be an indicator whether those are applicable for the state to go into the penalty phase. In other words, if the state is able to prove that it is felony murder, then clearly they can go forward with that aggravator. However, if the jury says it is not a premeditated murder, then they would not be able to go on that aggravator. And thus, that would be an appropriate and judicious way of finding what the jury thought process is at that point. And again, part of the reason why we're bringing this up now is that there seems to be, because it's a death case, there's a heightened due process requirement. It's not like, and I think the state is going to present you with a case, and I read it, and that was not a death penalty case from my recollection. It is a situation where, because the ultimate penalty is sought, we have to know what the jury's and what they're thinking regarding to which version of the first-degree murder do they believe the state has proven beyond a reasonable doubt. And so it's not something unique. Whenever we have enhanced sentencing, of course, we have special verdict finding, and I think even in this case, we have them. If you want an enhanced sentence, and there's an enhanced sentence for weapons, there has to be that special verdict finding. If you want to have a firearm case where did the person possess a firearm? Did they fire the firearm? Did they injure anybody with that firearm? It's because there are so heightened penalties in those cases, then of course they need to be able to tell the court that. In this particular case, it would be smarter and simpler for them to say, okay, in this particular case, yes, we have found during the commission of the murder, did the defendant commit the murder with premeditation? And again, they make that decision. That goes to what the sentence enhancements could be, and that could be determined later because then they have taken on the role of the sentencer. Much like in a case with a firearm, jury makes that determination, and because the sentence is a little different as the court, then the court makes the appropriate sentence on that particular case. And the second special verdict form, if you found him guilty of first-degree murder, you must then answer the following questions. And during the commission of murder, did this defendant commit the murder while engaged in the commission of a kidnapping with intent to inflict bodily harm, or terrorize, or carjacking with a deadly weapon, or robbery? Again, this puts us on notice and makes the jurors' thought process about how we're proceeding into the sentencing portion a more definitive and knowing decision. And so the absence of the specific findings by the jury, it violates the right to equal protection, due process, trial by an impartial jury in violation of Article 1, Section 2, 9, 16, 17, and 20. Yeah, I realized I was doing that. Okay. 2, 16, 17, and 22 of the Florida Constitution, and the 5th, 6th, 8th, and 14th Amendment to the United States Constitution. And so we're asking the court to also recognize that failure to grant the motion would be in violation of the due process clause of the United States Constitution, as well as Amendment 4, 5, and 14 to the U.S. Constitution. So that would be my argument, Your Honor, well, based on those two reasons. Again, I don't know how the court, this ever came about as far as what decision-making. It just seems there's just something inherently wrong when you can't find out what the jurors are thinking, whether it's either, again, premeditated or felony murder, because if they find that the state hasn't proven by like let's say a circumstantial evidence case, which in large aspects this is, then you would have an issue about what were their findings? What did they, in certain instances, again, premeditation would be something that they would say the state has not proven that. Even though the jury found it, we're in our capacity as reviewing because it's a circumstantial case, there's other factors that go into that, and they have often, not often, they have reversed based on the findings of a jury when they found it didn't meet the appropriate standards. So we're asking the court to allow for us to have these special forms.
Ms. Hicks, I'm sorry.
Yes, Judge, may I approach the case?
Yes, but yeah, yes.
Judge, the state is citing to Young v. State, which is 579 Southern 2nd, 721 from Florida Supreme Court, 1991. In a case of Halliburton, and it very clearly states that there's no merit to Young's other arguments regarding the charge of premeditated first-degree murder. Contrary to his contention, the state may proceed on theories of both premeditated and felony murder when only premeditated first-degree murder is charged. Also, a special verdict form demonstrating which theory the jury based its verdict on is not required, citing Halliburton from the Florida Supreme Court. This is settled law, Your Honor, that the defense doesn't get these special verdict forms.
I'm sorry, Ms. Hicks, where are you on the case?
I was on head note 4 and 5 on page 4 of the opinion.
I got it. Thank you.
And The defense's concern about the penalty phase is not well-founded because the jury in the phase has to they tell us which aggravators they are finding beyond and to the exclusion of any reasonable doubt. So their concern that we're not going to know what's happening going forward is not a valid concern because the jury is going to tell us whether they found the cold calculated and premeditated aggravator, whether or not they found in the course of a felony aggravator. And so that's not, they don't need to, there's no legal requirement for us to give this special finding at this time. And their concern about why it should be given is not well-founded because of their concern about the penalty phase and not knowing what's happening in the penalty phase is going to be cured by the penalty phase verdict form. What they are essentially trying to do here with this verdict form is suggest to the jurors that they have to find unanimously together that one of these two theories, or both, was found, and that's not what the law requires. And so these special verdict forms are in complete contradiction to the special instruction that you've already ruled you're going to be given, that we talked about. It's actually been given twice. And so if you were to have them give these special verdict forms, it would be in complete contradiction to that instruction that you've already said you're giving.
Mr. Lauren?
Yeah, and I'll be brief. Again, in this particular case, there was not the death penalty being sought. And so we think that makes it a bit different. There's heightened due process requirements. And again, I realize in this case what it stands for. But again, in that particular case, the death penalty was being sought. And I would point out, and maybe this is not necessarily a great example, but hopefully what happens at some point, the judge recognizes the error in just saying it with a broad stroke. Well, either way, if you get one of them, you get both of them. You can proceed on both theories, which I think was one of the questions that they were answering. But the problem is again, there's no knowledge that they are going to make an informed decision whether the state has proven all of the elements, especially in a circumstantial evidence case, whether there's premeditation or whether there's felony murder, then they have to be able to know which one they're actually working with. Are they with the felony murder theory, or are they working with the premeditation theory? And of course, they can always go back and review it and make the correct decision. I mean, we had Plessy versus Ferguson, which last year, Plessy, Plessy versus Ferguson, which for years, if I'm correct in my constitutional law, was separate but equal. And then Brown versus Board of Education turned around and said, yeah, that's not true. And so they changed the way that they reviewed those things. So again, I would ask the court to grant on request for special verdicts.
Just one quick point, Your Honor.
Pardon?
Just one quick point. I guess I'm a little confused why defense counsel keeps referring to this as a circumstantial evidence case. We have not one, but two confessions.
Mr. Lauren?
I'm sorry, I wasn't really paying attention to that. But again, it's still a for there may be other factors that may show that the evidence hasn't been proven, or there are certain aspects of it that would cause a reversal on one and not.
And Mr. Lahr, do you have any case law supporting your position that calls into question the continuing validity of Young v. State?
There is a dearth of case law regarding that aspect. So no, I have not found it. However, to me, it just seems logical and more informed to make that request for them to do a evaluation of what evidence they have before them.
And is there any case law addressing this issue with respect to the penalty phase? Is because in looking at Young, it didn't really address this in terms of the penalty phase argument that I'm hearing defense raised, meaning, I mean, it's clear that it's required in terms of the verdict of guilty or not guilty. That's what was the issue here before Young. But has any case just even addressed the issue of an argument that it is required for some reason, if requested by the defense, because of this penalty phase issue?
No, Your Honor, again, what we're asking is, again, because of heightened due process, that would be appropriate for us to have that information.
Judge, I'm quickly looking to see the case that, the Young case cites, Halliburton, I'm quickly looking to see if that's a death penalty. Yes, the case that is cited, Judge, Halliburton v. State, 561 Southern 2nd, 248, is a death penalty case. Now, I haven't read it, but I'm just reading the synopsis that says he was convicted of burglary and first-degree murder and second death, so.
Which case?
The case that, you're looking at Young in
Right.
paragraph, in head note 4, where it says also a special verdict form demonstrating which theory the jury based its verdict on is not required, and it cites Halliburton. That Halliburton is a death penalty case.
Okay.
My understanding of your question, has there ever been a death penalty case that addresses this issue? And it appears the answer is yes.
Well, in part, yes. I was asking whether a death penalty case with respect to what, if I'm understanding the defense argument, how it relates to the penalty phase. And that is, as I understand Mr. Lahr's argument, that the state has to prove their aggravators beyond a reasonable doubt. And so if one of the aggravators that the state wants to present proof on is cold calculated and premeditated, that I'm understanding Mr. Lahr's concern, the reason behind this request is if clearly the law as it stands today would allow 6 of these jurors to find guilt beyond reasonable doubt on premeditated and 6 to find guilt beyond a reasonable doubt on felony murder, and come to one unanimous agreement, guilty, murder in the first degree. And there's no requirement from a guilt phase perspective of them to explain that any further. Now we go to the penalty phase. So if I'm understanding the defense argument, in that instance, the state should be foreclosed from presenting evidence on cold calculated and premeditated because 6 of the jurors didn't agree that premeditation was proved.
That argument assumes that the reason they wouldn't find him guilty of first-degree premeditated murder is because that's the element they're finding wasn't proven. There's more than that element to the crime of first-degree murder. And we can't ask them on each individual element of the crime, did you find this? He is assuming that if they would not be unanimous on premeditated murder, it's because we didn't prove the premeditated elements. And so now you're starting to really invade the province of the jury, because to really follow his argument, you would actually have to say, did you find this element? Did you find this element? Did you find this element? And then with respect to her, did you find this? Did you find that? Did you find this? And you start to dangerously invade the province of the jury. And this concern is cured by the state having to prove, beyond and to the exclusion of any reasonable doubt, each aggravator and the jury telling us. So if the jury doesn't find premeditated murder because we didn't prove premeditation, then the jury necessarily should not find the aggravator of cold, calculated, and premeditated.
So, Ms. Hicks, if I understand the state's argument and response, it is in the guilt or innocence phase, with respect to premeditated murder, the jury has to find that the state proved all of the elements beyond a reasonable doubt. And the rejection, perhaps, of one of those elements does not mean that the state is prohibited from presenting evidence and proving beyond a reasonable doubt the statutory aggravating factor that must be required, which differs from the elements. It is exactly as stated by the statute. The state must prove that the capital felony was a homicide and was committed in a cold, calculated, premeditated manner without any pretense, moral, or legal justification.
Yeah, what the
And it's not inconsistent that the state could do that even if one or more of the jurors found the state failed to prove all the elements of premeditated murder.
correct, because the elements of premeditated murder and the elements of CCP are not the same.
All right. Mr. Lahr, could you respond to the state's argument?
Yeah, I think I would stand on my prior arguments, Your Honor. Again, it's appropriate heightened due process, I would say, during the time periods of these older cases, Halliburton and those that defense teams have changed significantly. So we ask for, again, good question first.
All right. All right, having considered what's been presented to the court, I'm going to deny defense's request for the special verdict form. Based on, as previously discussed, the existing law permits the jury to come back with a verdict of guilty of murder in the first degree on either theory, and that is the current state of the law. That is permissible under the current state of the law, understanding the defense is asking the court to requested the court depart from that, which I denied, and I'm going to continue to deny that. Next, with respect to the issue of a special verdict form, that was addressed by the Young case, and it's clear that in the guilt or innocence phase, that is not required. The Young case clearly addresses that and cites the Halliburton case from the U.S. Supreme Court. And so that does not provide a basis for the defense argument. With respect to this defense argument of the potential impact on the penalty phase, that court has not been presented with a case that specifically addresses the issue in that context. However, I find more persuasive the state's argument that because of the existing state of the law with respect to the guilt or innocence phase, that the elements of the crime of first-degree murder are not identical and synonymous with the cold, calculated, and premeditated aggravating factor in the penalty phase, and the fact that the jury will be instructed that the state still bears the burden of proving any and all aggravating factors that it seeks to present evidence on beyond a reasonable doubt, that the defense concern would be addressed by those instructions, because if there are jurors, even though if the court, and I am denying the request, and we don't know if, for whatever reason, in the penalty phase, the jurors conclude that the state has failed to prove the aggravator beyond a reasonable doubt. Presuming without evidence to the contrary that jurors follow the law as instructed, and they will be clearly instructed in that regard, that does satisfy due process and the other issues raised that concern the defense. So for all those reasons, I'm going to deny the defense request.
Yes, sir.
All right, so if we can, I guess, make the revisions that we've already discussed and get a new revised version.
Defense counsel provided me with their, what they wanted in ground.
May I approach your?
Is that on the 3.12D?
Yes.
Okay, well, let's do this. It's about a little after 3:30, so we're gonna take a quick recess, and then we can come back and discuss.
And Judge, I don't
Yeah.
have any additional argument for this, it's just the written instruction that
Okay. All right, you can approach with it then. All right, thank you. All right, so we'll be in a brief recess.